I'm Dan Frith, and I'm here with my law partner, Lauren Ellerman, and we're going to talk a little bit today about depositions, what they are, how to prepare for them, what to be on the lookout for. And believe it or not, what you watch on TV and see in movies about what happens in a courtroom is not exactly accurate. For the most part, everybody knows what the witnesses are going to say before they ever get to the courtroom. And how do they know that? They know that as a result of the deposition process. And what is a deposition? A deposition is nothing more than a statement under oath. You will be in a room with your attorney, a court reporter, and the opposing attorney, and they will ask you questions that relate to you and your case. And all this information, the questions and answers, are recorded by the court reporter. And Lauren will share with you in a little bit some do's and don'ts during those depositions and how those depositions are used at court. But I want to spend just a short time with you talking about how to prepare for those depositions and what they're really like. It's almost as if you're going to a funeral or the actual courtroom. It is a very formal process. You are to dress accordingly. You shouldn't show up in cutoff shorts and tank tops, because the other side is judging you, and they are judging you the entire time of your deposition, and they're trying to figure out how well will you communicate with the jury, with the judge, and that is based on your ability to articulate what happened to you, how it's affected you, and also your physical presence, how you look and how you handle yourself, and whether or not you can look them in the eye and answer their questions directly. So that's sort of what the deposition process is like. You should always meet with your attorney beforehand. He or she will go over with you the specific areas that you can anticipate some questions and help you answer those questions truthfully. Lawyers are not going to put words in your mouth, but they're going to help prepare you. And that preparation is very, very important. We tell our clients all the time, the likelihood of success in the case depends a great deal on how those clients do in their depositions. So with that, I'll turn it over to Lauren, and she'll share with you a few do's and don'ts about those depositions.
Sure. So one of the things that I have learned is that the first rule of deposition is always tell the truth, right, Dan? You don't want your client to exaggerate. You don't want your client to answer a question one way that they don't fully know the answer to. And so the number one rule of a deposition, you're under oath, you're promising to tell the truth, is always tell the truth. And this is a hard one for me because I love to tell a good story, but don't exaggerate. That's rule number 2. Do not exaggerate. And let me give you an example of that. For example, in a nursing home death case, if we are hired by the child of someone who died in a nursing home, and in the deposition, the nursing home defense attorney says, well, Miss Smith, how often did you complain to the administrator that you felt the care that your mom got wasn't great? An exaggerated response would be, I complained every day. Every single day I complained. Well, then the follow-up question is, well, did you ever do that in writing? Or give me the names of some of the nurses. Or every single day you complained, why did you leave your mom in the nursing home? Clients are tempted to exaggerate because they think that will help their case, but really it doesn't. The God's honest truth helps your case. So if the answer really is, I recall complaining numerous times. One day I complained to the nurse at the front desk. One day I complained to the administrator in a nursing home. I recall another time where I saw so-and-so in the hall. So I'm sure it was more than 3 times, but I specifically recall 3 times. You as a witness gain credibility, and our case gains credibility. So rule number 1 is always tell the truth. Number 2, don't exaggerate. And number 3, if you don't remember, that's okay. Don't make it up. I have a 9-year-old. She loves to make things up. In a deposition, you don't want to make it up. Oftentimes people hire us 2 years after the incident, which means, or a year after the incident, which means their deposition may not be till a year and a half or 2 years after the incident. And it's difficult in a healthcare trauma to remember all of the details. So if you don't remember 100%, you need to qualify your answer and say, a doctor came into the room. I don't recall his name. I believe he looked like X. And so you want to make sure, again, that you're answering truthfully, and that if you don't remember, you're not making it up. And last but not least is answer the question that's being asked, not more. So Dan, you've been in depositions before where you had a client that maybe is a talker or wants to please somebody. And so what they do is they answer questions that haven't been asked. And what do you advise your client in that circumstance?
Well, just like what you just said, please listen. One good rule is listen to the question, pause before you start your answer. So you make sure that the question has been completed before you begin the answer. And invariably, opposing attorneys don't try to intimidate witnesses. They try to befriend them and get them to give them information that they wouldn't otherwise get. So that you need to be aware of that. You need to make sure that you're just answering the question. And the other attorney is not a bad guy or a bad girl. Their job is to help their case and to hurt your case. So you don't go beyond the answer to the question. And if you don't understand that question, or you need to understand or think about how you want to respond to it, ask the other attorney, can you repeat it or rephrase your question? I'm not sure I understand. That gives you the time to process your answer.
That's right. So just in summary, rule number 1, always tell the truth. Rule number 2, don't exaggerate. Rule number 3, if you don't know the answer, don't make one up. And rule number 4 is answer the question that was asked, nothing more. Now, Dan, tell me just the logistics of a deposition. Usually, where does it take place for our clients? What should they bring with them? Who should they bring with them? Who's allowed in the room, etc.?
Sure. Most of the times depositions are taken of our clients are taken here in our office. Sometimes they'll be taken someplace else, but for the most part, they're taken here at our office. They can bring whomever they want to our office, but typically only the deponent gets to be in the room during the deposition. So if it's a husband and wife who are going to be deposed and it's the wife's case, the husband cannot sit in the room while the wife is being deposed. After she's been deposed, then the husband can come in. And obviously the reason for that is they don't want one witness copying and just repeating what the other witness says. What do you bring with you to a deposition? Again, I think by the time the deposition gets there, you need to have already been prepared as to what you're going to say and what the process is. If you bring any notes or diaries or anything like that with you to the deposition and you use them to refresh your memory, the attorneys on the other side have the right to see those and they have copies of those. So if you're going to bring something to a deposition, we always tell our clients, Lauren, show it to us first so we can look at it before you bring it into the room.
Right, because you may have a duty to provide it to the other side prior to the deposition.
Right.
I tell folks, if you normally eat breakfast, eat breakfast. If you normally don't eat breakfast, don't eat breakfast. If you have to take medications at noon and your deposition is going to be at noon, bring those things. We want you to be physically comfortable. I have had nervous clients in the past take maybe their wife's Valium in the morning, and then they show up at the deposition and they're a totally different person. And I say to them an hour in, what happened, Frank? I mean, you were emotional about this in my office yesterday, but today you're not emotional. And Frank says to me, well, I didn't want to get emotional in front of that other side, so I borrowed a Valium. Terrible idea. Do not take medications you don't normally take. Emotion is fine. A lot of this stuff is hard. It's going to be difficult to talk about this. We bring tissues, but if you need to bring tissues, feel free. Bring a bottle of water if you're always thirsty. But don't change your routine on the day of a deposition. Don't start something new because you think it's going to help you.
Exactly.
All right. Dan, are we missing any other nuts and bolts for our clients who are preparing for a deposition in a civil case?
No, I think we've covered all the highlights. But again, obviously, regardless of what this video shares with our clients and others, it's really, really important that clients meet with and talk to their attorneys prior to the deposition so they can deal with every case is different. Every case has different facts. So attorneys, we prepare our clients based on the specific facts of their case. What we've shared with you today is basically just general rules.
Yep. Now, Dan, one last thing, and then I'll let you go. If in a medical malpractice case or a serious personal injury case, are the defendants usually attending our client's deposition? Meaning, is Dr. Smith, the orthopedic doctor, coming to our office and staring across the table at the injured party?
Rarely. Probably out of every 100 depositions we have in a medical malpractice case, maybe once or twice does the defendant doctor actually show up to hear and see our client, who is the patient's deposition.
That's right. Well, Dan, thanks so much. I appreciate it.
Thank you. Bye-bye.